Uh, hi everyone. I welcome each and every participant and also Mr. Shrijay Sheth from Legalwiz. He's a co-founder of Legalwiz and is an entrepreneur with 15 plus years of formative, diverse, and immersive experience base across varied industries and geographies. He has also been fortunate to have worked with some most of the admired e-commerce industries, also has a rare blend of commercial acumen and technical know-how. He loves to contribute his time to building technology-driven solutions that solve real business problems. Also, Legalwiz is a company deals with company registration and intellectual property rights. So I welcome you, sir. Thank you so much for joining the session. Over to you.
Thank you so much for having me today, and for the opportunity to interact with fellow entrepreneurs and other members. And thanks for a very warm welcome. My name is Shrijay, and I run a company called Legalwiz.in, which is a legal tech platform where we provide legal company secretarial, chartered accountancy, and taxation related services across India, and overseas now as well. So with just a little bit of background about me is I've been part of the legal tech domain for about 13 years now, with 6 years plus that I've been with Legalwiz obviously as a founder, and then also prior to that I used to work with a company called LegalZoom, which is a world leader in the domain, based out of California. So a lot of experience that I've gathered over time, whether being an entrepreneur, whether being a business person at an intersection of legal, technical, and business. It has really been fun, and I wish to share a lot of experiences that I've gathered so far, and talk more about intellectual property and how to protect intellectual properties in India. So without actually taking a lot of time in introduction, let's let's kind of start taking a deeper dive into intellectual properties and today's subject of talk. What is an intellectual property? Or a lot of times we discuss about the businesses nowadays being more intellect driven as opposed to a lot of physical asset driven, right? And if you might take an example of business models like Uber, or being the largest cab company in the world, or you might take an example of Airbnb being the largest accommodations facilitation company in the world. A lot of these business models are really getting nimble, and so when I say they are getting nimble, that is um, one where they deploy a lot of technology to make the business models very scalable, but at the same time they are not holding on to a lot of physical assets, right? And so a lot of these companies valuations are also largely driven by the intellectual property that they have in place, or the unique business models, or the inventions and innovations, and obviously enormous amount of spends and resources that kind of go after creating a brand value for the companies, and so on and so forth. So all of these efforts and all of these properties, or all of these asset classes that they build for themselves, which are not tangible in nature, typically we would try to identify that as a intellectual property, right? Something which is not mostly just a physical property, like a building, or an office space, or all those kind of things. Something which is a creation of an intellect, and that gives you an edge as a business to either create exclusivity in branding that gives you an edge over competition in terms of exclusivity in using of certain type of combinations, or the products that you have built, which are inventive or innovative in nature. The artistic or literary work that you have put together, which gives you certain type of exclusive usage right over it, and stuff like that. That is in a very broad nutshell, that is all part of the intellectual property. Now how so most of these businesses keep creating the intellectual property, and it also is very important to protect it, right? So when we talk about, especially when we talk about startups, right, and they are intellect driven, what gives them an edge if they have an exclusivity of usage, right? So if that is something that not other competitors can use in the market, and that becomes sort of a monopoly of them, that is where the most of the value of the intellectual property lies in, right? So when one thinks about why should we actually register an intellectual property, or why should we go for a trademark registration or patent registration, the first thing first is it is an intellectual driven and created asset, which is an intangible asset that you would want to actually create, which contributes to the valuation of your company, and it becomes it becomes an asset base for the company, right? If you actually end up owning that particular intellectual property, obviously you have a proof of ownership, but at the same time an exclusivity to use that intellectual property. So whether that is a brand that somebody else cannot copy, or whether that is a particular invention that somebody cannot launch as a product, and you have an exclusive rights to offer that particular product in the market, and so on and so forth. Also, there are a lot of commercial benefits attached to it, rather than the exclusivity, which we obviously brings a huge commercial benefit, because you are actually cutting down on the competition in a very big way. But also at the same time, let's say if you are just an inventor or an innovator, or if you have created a brand which you also want to extend to other revenue streams, then you can also assign, or you can sell off, or you can lease and license such ownerships to others to kind of reproduce work, wherein you can either earn through the sale of the property, or you can earn through the royalties that you get, or a recurring revenue stream. So it also helps a lot of property owners to actually create additional revenue streams out of their intellectual property possessions, right? And finally, obviously, if you hold on to a particular intellectual property which gives you so much more of a benefit, it also comes with a set of goodwill that you create for the business. So ideally, in a nutshell, if we think about owning an intellectual property, it is obviously the competition that you are cutting down, the exclusivity of usage that you are getting, which helps you create a brand, which helps you make a better competitive position in the market. And if at all you end up deciding that you are not going to use it, or you are going to not or you are going to use it for a limited purpose, you also have an opportunity to create additional revenue streams out of it by licensing it, by leasing it, or by assigning or transferring that intellectual property, selling off the rights to somebody else. So in that sense, it becomes very important to actually claim the ownership through the registration of the intellectual property. um, and if at all anybody has any questions, while we are discussing this, it is going to be a lengthy session. So if at all we want to make it interactive, please feel free to kind of drop down your comments, or questions in the chat section, and more than happy to address those as we speak about things. So typically, there are a lot of different type of intellectual properties, right? And majorly what we are going to discuss today, which covers the largest spectrum of the intellectual property rights that are granted in India, one becoming your trademark, right? The second one is your copyright. The third one is a patent, and fourth is an industrial design. Right. So as a very basic rule of thumb, we are going to say that anything that really adds up to a branding element of your business, of your company, of your product, something that your users or your customers use to identify and distinguish your product from the other products or companies that are available in the similar domain as your competitors, that is usually qualifying as a trademarkable item, right? Against which copyrights is, it's a novel creation of an artistic work or a literary work, which you would want to protect and own the rights to. For example, you have written a book, you have written a song, any sort of those sort of artistic or literary works typically become a copyrightable item. Patents very strictly deal with the inventions and innovations, right? So anything that you have built which is inventive or innovative in nature, something which is not pre-existing, and it has a commercial usage of that, that is usually a patents, that falls under the patents category. And then finally, anything that is a specific design element attached to it, which is a unique design, which is a novel design of your own creation, which kind of gives you an exclusivity to reproduce those designs, that will usually go under the industrial design section. So trademarks, copyrights, patents, and designs, wherein trademark is largely about branding, copyright is largely about um, the content or artistic or literary work that you produce on a novel basis. The patents are inventions and innovations, and industrial designs typically deal with the exterior design elements of the products, right? So having said that, we are going to kind of take a deeper stab at each of these each of these IP products, and try and understand them more, right? So as we discussed, trademarks obviously is anything which helps your customers, helps the outer world distinguish your branding as compared to the branding of the competitors, right? So anything that is either uh, you know uh, whether that is the name of your brand, whether that is the logo, whether that is a graphically representation which helps people identify you as a company or you as a product, all of these things typically get into a trademark, trademarkable items, and it is governed by the Trademarks Act of 1999 in India, right? So what are the various type of trademarks? So a generic type is typically something which is understood to be a very common word, right? For example, Apple, or all those kind of words which are typically and very generically known by people, versus a suggestive mark is something which actually suggests what kind of industry that you are into. For example, Netflix for that kind of gives you a hint of it is internet based item, and it is a streaming films online or streaming media platform. These kind of things could be categorized as a suggestive mark. A typical descriptive mark is something which is a description in itself, right? So either the characteristics or the functions or the feature or the purpose of that particular product. For example, if you say cold and creamy ice cream or something like that, so cold and creamy becomes, if that's your brand name, that becomes a description of the product in itself, which kind of qualifies for a descriptive mark. And then arbitrary mark and fanciful marks are arbitrary, something which it's very arbitrary in nature, which has come from kind of pulling off various words, and if you are a fanciful mark, something which is non-existing in nature, and you are going to something which is more coined in nature. For example, we say Google. I mean, it doesn't really mean anything, but now it means a lot, because obviously a lot of identity that that is attached to the word Google, for it being a company that produces work in certain industry, and so forth. um, right? There could be words, there could be logo, device, or shapes and packaging, right? So there are various different things that give a business an identity, right? If you talk about the word, it could be a company's name, uh, you know uh, that qualifies for a word. Sometimes you also might have a unique logo. For example, your CNBC has like a peacock looking logo, or an Apple has a bitten apple as a logo, right? All of those are typically devices, versus there could also be shapes from which you make your you make your identity of the product. And Toblerone, probably one of the very classic example of that is, they always come in those triangular shape chocolate bars, and since that has become an identity in its own, that is uniquely protected by a trademark. So nobody else can actually produce a chocolate chocolate bars in that particular shape, which are kind of the cone shaped, triangular in nature. And so that also becomes a unique representation of your own product, and people can very quickly and distinctively identify that being your product with somebody else who is a competitor. And eventually it can also be your packaging, and how your packaging becomes an identity for yourself. So in a nutshell, everything and anything that really defines a particular identity for your product services can simply be qualifying as a trademark. um, so specific type of the trademarks, if we discuss, right, there is a service mark, which is typically refers to the non-product items or the services items. For example, an airline company which has a servicing as a that they give for flying services or passenger related services. There is a certification mark which typically is the mark that that more or less adheres to the local regulations, as contrary to the other type of trademarks where the certification marks authorize the user and not the owner, right? And some of the examples of those certification marks could be I believe it's probably like the Parmesan cheese of Regino Parmigiano, which kind of belongs to a particular territory, and that could also be like a collective mark, right, wherein it's not only one owner driven, but it is an organization or an association that kind of gets a collective identity. Patan Patola can be one of the examples of that, and so on and so forth. There can be a trade name that the company uses. So a lot of company they have different names for their private limited or their business structures, but at the same time they use trade names which are very popular in the market. For example, Procter and Gamble or P&G owns trademarks such as Oral B, which is a very popular product in the toothpaste market or the toothbrush market. Right, so maybe NK Proteins, being a local company to Ahmedabad, owns a trade name brand called Tirupati Oils. So that also gives them a distinctive identity, not just by the company's name, but also by uh, the name of the product in itself, or the name that they use for trading their products. Sound mark is also, it's a little novel, and some of the popular examples could be Yahoo's Doodle, or Britannia has a very is also one of the registrants of the sound marks in India, wherein um, the jingle-ish sound that they have, like that kind of gives a unique identity. So if you actually hear that sound, you can recall the brand, and so a sound also becomes an identity of the brand and something that can be protected through a trademark. Then there can be holograms, there can be motion marks, and so on and so forth. Scent is something not very widely popular in India, but at the same time, if you were to kind of find a very classic example of a scent mark is there is a brand called Abercrombie and Fitch, which is a very popular young young people clothing brand in the US and other countries. They actually use a very typical and the same fragrance in of perfume in all the stores that they own across the globe. And if you enter that store, just with that smell, you can even if you don't see anything else, you will be able to figure out that you are in an Abercrombie and Fitch store. And so the scent becomes a unique identity of their brand. And so in the scent mark can be something that can be looked into protecting. So these are some of the examples of things that that can be protected through a trademark. So we are talking about um, names like Shah Rukh Khan or Taylor Swift. These guys very popular and consider their names to be protected, right? So they get an identity over it, and they can protect, and they can kind of create those, as a brand labels, and eventually commercialize it, so on and so forth. Abbreviations like LNT or BMW, is a good example of abbreviations which are popularized as brands, and so need to be protected by trademark, so nobody else can actually start using it. Numbers also create great identities, and what more than what better example than the number 007, which unanimously across the globe people would kind of relate that with the James Bond character, and on the screen. So that can also create an identity, a unique identity for the brand of James Bond, and the company that produces the work, to create that character, and filming it, and so on and so forth. So that could be another good case of how the numbers can actually be trademarked for a particular for a particular brand. There can also be tagline, so it doesn't always have to be the name of the product or anything like that, but you can also think of um, any other slogans, taglines that really give you your business and identity. For example, McDonald's is very popularly known as "I am loving it," or back in the days, Reliance, when they started with the mobiles, they had a very famous tagline, "Kar lo duniya mutti mein," or um, you know Adani nowadays use "the gateway to goodness" or something like that. And when people hear about these taglines, or Nike has a popular tagline called "Just Do It." So when people say "Just Do It," or people say "I'm loving it," they actually can relate to brands like Nike or McDonald's very quickly, and so that becomes point of identification of the brand, and something that needs to be considered for registering as a trademark. So actually, given this scenario, let's take an example of of McDonald's, and how there can be different components, a particular signage that you see outside the outside the eatery shop of McDonald's, right? So there would always be that golden arc, right? Then there would be a word called McDonald's, and then there is a slogan that is written, "I am loving it." Now the golden arc in itself becomes a device, um, right? And it's a logo that people identify as a unique identity of McDonald's, right? So even if you don't really read out McDonald's as a whole brand, and you just see a golden arc, from a mile away, you would be able to figure out that, okay, I'm approaching a restaurant of McDonald's. And so the golden arc in itself is an identity of the brand, the same way the whole name McDonald's is an identity of the brand. And also, when people say "I'm loving it," then invariably you figure out that they're talking about McDonald's as a food business. And so all of these different components make a different use and good use case of brand protection through a trademark. Right, typically, so what can be trademark, we generally kind of went through that. I think we must also understand what cannot be trademarked, right? Um, so a very good thumb rule is anything that's already been taken, anything that causes an infringement for other brands, or a misrepresentation or confusion with the user base, anything that is not distinctive, right? Anything that is illegal, obviously cannot be trademarked. So these are some of the things. Also, at the same time, something that is very descriptive, or something that is an obvious word for defining that industry, is something that cannot be trademarked. So to give or take a few examples of that, let's suppose I would I would open a pizza making shop, and I say that I'm going to name it Pizza Maker, uh, as a brand, right? Now that is very descriptive of the industry. That is the core business that we do. So if I get a trademark rights over it, then nobody else can use it, and eventually that is not going to be a fair competitive landscape. And so something that is, kind of set for an outright rejection. At the same time, something which is very illegal in nature, could also be potentially, uh, an outright rejection. um, Things which that would create confusion in public. So a false claim, for an example, something that your product can never deliver, but you are making your brand identity such that it becomes suggestive of that delivery, which can't happen, and so that could be a good grounds for a trademark rejection. Something which is very commonly used in market, or people use that as a common lingo on a day-to-day practice, is not something that somebody would be able to claim, the mark over. Something which is already prevailing in the industry, and you are just shuffling a couple of words. We are probably going to see a couple of examples of those. But if there is a popular existing brand and you are just kind of creating a mark or creating a brand with same pronunciation, same spelling, or same kind of look and feel, same kind of expression of colors, logo, device, and it creates a confusion in the user whether that is the other competitor that they are talking about, or or it is you. These are some of the cases where it can be set for rejection. um, so having said that, a very popular question and a lot of people have a confusion about is, what is a TM and what is an R symbol, right? And to kind of very quickly go through that in the essence of time, when you make an application for trademark registration, it has a long process to it, and which we are going to quickly go through the process as well in today's presentation. But if you haven't applied for a trademark and it is under a review and it is not yet registered, which is typically a year-long journey, or more or less depending on the stages that you clear and cover. At that point of time, you can use a TM symbol over your brand, and whenever it becomes a registered mark, so at that point of time, it is an indicative of an ownership for that particular brand name, and that is when you start using an R symbol over it, right? So we are going to go very quickly over the registration process, because we also have to cover the other um, other marks and categories, or other intellectual property types. But the most important thing is to define a right class. So when you start a trademark registration process, you must know under which class is your mark falling, right? So that typically is defined by the business activity that you do. There are about 45 different classes, which are either divided into products or services, and when you apply for a trademark, you have to apply for a particular class protection, which relates to the business activity that you do, whether it is, let's say toys, it is business materials, it is computers, it is, e-commerce services, it is chemicals, it is textile. And so when your trademark gets registered, the protection is limited to that particular class. And a good example of that can be, let's say an Amul as a dairy brand also coexist with an Amul Macho as an underwear brand, right? And they all have the same spelling. Now it is a different story, probably because Amul is being recognized as a popular brand, and so they by default would get uh, a coverage under all the 45 brands. So the popular brand is something which is granted a status of being a popular brand by the ministry, and they have a wide coverage across all the 45 classes. But if you are a small brand, um, then ideally your protection is limited to the classes that you apply for, right? Then once you do the trademark search, and within a particular class, so you define the classes first. Within those particular class, you make a trademark search and make sure that there are no other brands which are similar sounding or similar looking, and there is no possibility of being called out as an infringement. At that point of time, the trademark search helps you in getting a clarity over there. And then finally, it becomes a filing process. In the filing process, we are not going to go into detail of the um, of how the process works out, but essentially, once you file it, then there are three stages to it. So when you make an application, it goes to the registry for a review, and at that point of time, you will get an objection. You may get an objection. Objection is when the trademark assessing officer finds out that this is either one of the things that we discussed about the grounds of rejection. There is an objection that might be raised, and you have to duly respond to the objection. It might go into the hearing at that point of time. Let's suppose we move forward from the objection state, then it moves into a trademark journal publishing, where it sits for about 4 months, and within the trademark journal, it becomes available for common people or the third parties or the external companies to figure out that there is a mark which is in the process to registration. At that point of time, they can create an opposition over it, and the process again remains the same, wherein you get an opportunity to respond to the opposition that is being filed against you. And if it goes through, then it goes through the registration process, and you eventually can use a registered mark logo over it, which is like the R covered by a circle. And if not, then it might get a rejection at that point of time, or it can go into a hearing. And obviously there is a due process, to get through the hearing, stuff like that. So that is usually the process. If we talk about the process length, typically it takes about we've seen maybe at the best about 6 to 8 months, at the worst about a year and a half, 2 years, to kind of get through the entire process. So the trademark registration process is lengthy, but at the same time, when you actually make an application for trademark, at that point of time, your application is in and you can start using a TM symbol over it. And it also is a claim of a usage or proposed to be used at that point of time. If you have a prior usage, then you can also specify the prior usage at the time of application itself. And so your usage or the ownership of the mark is being considered from the time of the usage was actually started. So let's say you are an old brand, but you decide to file for a trademark very recently, you can actually claim a prior usage, and that establishes the grounds for you. If somebody else comes and opposes that registration, then at that point of time, if you have established prior usage, it is very likely that the case would go in your favor. Right. And Malik Chand versus Manik Chand becoming a very prominent case in that, wherein there is a small town brand called Malik Chand Gutka who actually was able to establish a prior usage, and so the entire Manik Chand brand, which had to kind of invent their brand in the name of RMD, or the Rasiklal Manik Chand Dariwal group. So there are some very iconic cases around having a prior usage establishment, and how that can impact your ability to protect the brand name. So for how long a trademark can be protected, right? Usually the small answer is in perpetuity. The long answer, it is subject to renewal, right? So the trademark is owned in perpetuity as long as every 10 years that is renewed by the owner. um, right. And one very commonly asked question is, if I register for a trademark in India, does it actually grant me a protection internationally? Again, the short answer is no, it does not. Trademark are typically territorial in nature, but at the same time, there is also a formal process, whereas under a treaty, and the World Intellectual Property Organization, commonly known as WIPO, has laid down a common practice where participating countries can facilitate the trademark applications through a single platform in a multiple countries. So at that point of time, obviously the granting of the mark, or the granting of ownership of the mark has to go through every country's in the process in each. But if you go through WIPO, then you can take an advantage of your home application as a basis, to start with. So if you are a company primarily founded in India and you have an application in India, that becomes your base application, and then you can extend that through WIPO under a Madrid protocol in various different countries that you would want to protect. Alternatively, if you are only trying to protect in one or two other countries, you can also independently register a mark in those different countries. You can make an application in the US through a US PTO, and that also can be one of the ways how you can protect trademark in other international markets or countries. Ideally, where should you protect is, a lot of times there is a common myth that the trademark should be filed in the country where your company is registered. Ideally, I would suggest the mark should be protected where you expect the most usage, or in other words, abuse, right? So if you are a company that is registered in India, but you're exclusively selling your goods in the US, it is highly likely that somebody is going to infringe your mark in the US and not in India. And so ideally, what you would want to do is you would want to protect your identity in the US, more so then you would want to protect that in India, because in India you are not actually a popular brand, but in the US you might be very popular, right? Um, some of the very standard cases, or very interesting cases, let's not go into a lot of those, so we have a lot to cover, but I think there is one very interesting, which is Starbucks being a very popular international coffee brand, and something which started as a brand called Sardar Baksh. And so in this case, obviously the logo also has some similarity in the sense that it is using the same color combinations and whatnot. At the same time, it is a very similar sounding name, and so that actually is not a great case of ownership of the mark. And so eventually they had to kind of change their brand to be called as Sardarji Baksh, and then eventually they also ended up protecting the word only Baksh, so somebody else cannot then replicate that in that case. But if you kind of uh, how the Sardar Baksh is pronounced, it is very similar to Starbucks, and it clearly establishes a case that they're sort of trying to make an infringement over here, wherein they're trying to bite into the goodwill of Starbucks that has been created over the decades of presence that they've made in several countries, and so on and so forth. um, right, so that's largely what we wanted to discuss today about trademarks, and how they should be protected, the process, what can be trademarked, cannot be trademarked. But more or less what I would leave you guys with a thought about trademark is, anything that really adds value to your branding element, something that you would really want to think of protecting under the Trademarks Act of 1999. And may that be a name of your company, a brand name that you're using, if you have multiple products and you're using unique names for those products, if it is a logo, if it is a symbol that you're using that demonstrate your brand or product, whether it is a tagline that you use, that gives the users that recall of the brand, whether that is a distinctive shape that can be categorized as an identification point for your product, like a Toblerone chocolate. All of these things which will give your business an identity is something which is trademarkable, in a nutshell, right? Um, so moving on from trademark to patents. Patents, it's typically anything that is inventive or innovative in nature, governed by the Patents Act of 1970. um, any any invention that you are making, any significant uh, process improvement, mechanism improvement, composition improvement in cases of drugs and drug UPIs and so on, so on and so forth. um, all of these things, and it might just not be an invention, but it can also be an innovation. So the patents can also be filed on something which is pre-existing and patented if you are building upon that, and which is, an innovation in nature, or it is creating an enhancement to something that is already available. That is also usually, patentable. A good example could be, Qualcomm, as a company, started, patenting the core of the CDMA. The founder, Irving Jacobs, was the professor who, who invented CDM as a technology, as opposed to the GSM, which was, popular in the European nations. So that becomes a patentable item. But at the same time, over all these years, they are also, improving, improvising, changing a lot of different things, and enhancing the performance, and several hundreds and hundreds of patents that have been filed only under the domain of CDMA and CDMA technologies, which kind of keep giving them more and more edge as they move forward and evolve as a business, right? So all of these things typically is something that you would want to kind of consider to be patentable. Right, again, as trademark or any other intellectual property, patent also gives you a lot of financial and protective benefits. So obviously the ownership of your investment in time, resources, money, everything that you spend after creating a particular invention or innovation, you would want that exclusivity. You would want only your company or yourself to be the primary producer of that particular technology. And so the ownership right or the exclusivity right is very important. uh, you know at the same time, if you are an inventor, innovator, and you don't want to really produce that, you also have an option to create revenue streams by licensing it, by selling off your patent, by transferring the rights of production and earning royalties out of it, and so on and so forth. So for all of these benefits, if you think that something that you have created is very inventive in nature or innovative in nature, and something that is a commercial benefit, which is not pre-existing at this point of time, is what you would definitely want to consider, kind of getting a patent rights over it. So what are the essential things and things that we kind of also discussed while we were talking about patents? Is one, definitely it has to be novel, right? Something which is not pre-existing in the market. There also shouldn't be any literature out in the market, and so even if nobody has made a product like that, but at the same time, a research paper, a literature, and a know-how of that is available in the public domain, that is also something that cannot be patented. That is also something that cannot be patented, right? um, it has to be a non-obvious thing, right? So it can't be a very obvious thing. It has to be an innovation, invention, for which there has to be a substantial amount of thought process that has to be gone into it. And so something which is very obvious and natural to the course of business, or is not what usually will be patented, right? It has to be obviously bona fide in manner. So it has to be a legal work, it can't be illegal, and it has to have an industrial application. So it has to be attached with a commercial benefit. It has to be attached to some sort of industrial application that you can create over that product, or the invention or innovation. So these are typically four founding principles of what can be patented. Right, what can not be patented is anything that is just a discovery, uh, or anything that is pre-existing, something where you say that is available in the public domain. It's just a restructuring of the existingly available components, or existingly available technology that is out in the market. um, so so those kind of things are typically something which you would not be able to patent, right? Um, so if you know um, and then obviously there has to be a commercial interest attached to it, and it has to have an industrial application. um, something which is very commonly known as a substance, or something which is very commonly known to public, and those sort of things, which ideally wouldn't be the right candidate for being patented. uh, right, so um, yeah, we sort of kind of went through this, and I can share the PPT in the best interest of the audience today, and we can go in detail. But ideally, what we are looking at for patenting is things which are novel, things which are inventive or innovative in nature, something that is not pre-existing in the market, either in terms of product, services, or in terms of the literature that is out there in the know-how, something that is a commercial an industrial application to it, something which is not very obvious to people, not not a natural expression, something which has uh, you know which would have a considerable amount of thought process that would go behind to kind of improve the efficiencies, which are measurable, or which are obvious from what is existingly available out there. So if it does not demonstrate efficiencies, it does not demonstrate improvement from what is currently available as a substitute in the market, then that's also not typically categorized as the invention worthy of patenting. Also, in India, commonly we get asked whether a software can be patented. Unfortunately, in India, that is not yet a reality. But at the same time, if you can bring in a hardware component to it, right, and along with the software and hardware, you can call it out as a system, and that novel hardware actually works in a better efficiency with that piece of software, and which becomes a system in its own, which has an industrial use that can be considered to be patented. But a piece of software, or the line of codes at this point of time in India is something um, which is slightly out of the purview of patenting. Right, who can apply for the patent? Obviously, the true or first inventor or innovator, but at the same time, if they have a legal assignee, or if they have a legal representation, they also can file a patent on their behalf. So anything who is inventor, innovator by himself or herself, or somebody who has explicitly gotten a right to do so, whether that is a legal assignee or a legal representative, of the deceased investor, or an assignee, that they can file for that particular patent and claim that as an ownership. Um, right, so when we talk about patent, usually there are three things, right? So there is one, which is your patent search, um, right? Then there is a provisional patent. There is a complete or full specification, right? So usually a patent search is a professionally done search, wherein we find out um, which are the closest competitive patents which are available or registered already in the market. And why patent search is very important is it is because of two things. One, if something alike is already available in the market and there is no differentiation, or available already, as patented, and not there is not much of a differentiation, then there is no point of moving forward with the patent application, since it is pricey, and obviously the registration is very bleak at that point of time. Um, but at the same time, also it's a discovery phase where a lot of people realize that there is similar there are similar uh, applications that are available, but then you can draft your claims in a way that it highlights the differentiating point. And at that point of time, it actually helps you draft your patent application if you have done the search right, in a correct way, and so it also improves your possibility of, or the chances of actually getting a patent registered. Right, a provisional patent is something where you are working on an idea. You don't really have you haven't completely concluded your work, but at the same time you want to make sure that that particular idea and the process that you're working on, um, it remains available for you as on an exclusivity basis. At that point of time, you would go with a provisional application. The provisional applicant gets 12 months to file a full specification or a complete patent application. Within those 12 months, there is an opportunity to evolve and finish the development uh, of your invention and innovation. And the benefit of that is the moment you file a provisional application, you get a foot in the door, and so you get an application date frozen as the date of filing the provisional application. So if during those 12 months while you are still working and finishing up your product work, if somebody else comes in, files for the similar patent, your foot is already in the door, and so you get a priority date against it, right? So that is why if you're working on an invention, it's actually a great idea to file a provisional patent. And within 12 months you file a full specification, which includes all the details, the diagrams, the benefits, the claims that you are making in terms of what should be protected and why it should be protected, and what are the benefits that are that are available, how you're improving the existing efficiencies, and so on and so forth. That all goes part of your complete application or full specification application. So it has a description of your invention, the best method of performing, how your invention is going to perform at the best capacity, the claims that you make around the protection, and eventually the abstract of it, right? Wherein the claims and abstract being the most important and the heart of the patent drafting, where the claim should not be too broad that it is set for rejection, but at the same time it should not be so specific that it can be minutely changed here and there, and then there is no essence of patentability at that point of time. So that needs to be taken care of very well. Right. And finally, how we have WIPO facilitating the trademarks the same way. PCT applications under WIPO, they also have an applicability overseas for patent. Again, patents similar to trademark are also territorial, but at the same time, if you would want to proceed with an extended protection in other countries, you can actually go through a PCT filing method under WIPO and apply for the protection in other countries. But it has to be explicitly applied and not not something that just assume to be having the rights in and across the globe. Right. Um, so we discussed about why one should actually file a provisional patent. So this becomes a little repetitive, and we'll move on. Process of filing, let's not really go too much in detail, but ideally it is very similar process. You make a filing application, the publication happens after 18 months. Unlike the trademark publication, it has to be explicitly request for examination in this case, wherein in trademark you get an examination report from the ministry, and then you just have to respond to it. This is a explicit request that you would have to make, and eventually it goes into the registration. But at the same time, the patent rights, unlike the trademarks, which are perpetual in nature, the patents are typically 20 years at the max. That you get the exclusivity, and after that the technology or the invention becomes available to the generic usage, right? So that the patents are typically protected for 20 years from the invention. Right, some of the um, some of the examples, pharmaceutical companies becoming very big use case of patenting, because they spend so much money into research and development. They really want to protect that formulation, so that they can recoup all that money and make profits before it kind of becomes available as a generic category. Right, so there are some iconic cases, for example, the Bayer Corporation and the Union of India, where actually the patent the patent was granted, but at the same time, the product was so exorbitantly priced, and it became an essential commodity for curing very specific disease, which is liver and kidney cancer. And somebody else could actually demonstrate that they can lower down the cost dramatically and make it available to the public as much as 3% of the cost that the Bayer Corporation was selling the drug at. And at that point of time, they were given a right to reproduce. And so there are some really iconic cases around around what is the extent of your patent protection, and what are the cases where you could lose some. um, right. The patent obviously can be transferable. So as we discussed in the intellectual property, you can actually create a recurring revenue stream by either transferring the patent or leasing it out, and earning in terms of royalty. Right. So the right of usage or the right of or the transfer in itself can become a revenue stream for the inventor or an innovator. So a lot of times what happens is people invent things, but they don't really have financial bandwidth or capacity to actually mass produce that and reach to the markets. In that company, the inventors go to the bigger companies and license their inventions for a reproduction right, and so the bigger companies eventually become the business that takes that to the market, against which the inventor or innovator keeps kind of creating for themselves a recurring revenue stream. And so there are some good advantages. If you own a patent, you have an exclusivity which you can transfer the rights to the others and make revenue stream out of it, right? So that's patent. And then obviously we have designs, right? So design is something which does not deal with the internal mechanism, but largely deals with the exterior look and feel of the product. So if that becomes a unique expression in itself, that is something um, which can be considered as as a design registration. The design registration falls under the governed by the Design Act of 1911. So anything that is any exterior design expression that becomes a result of an artwork, drawing, graphics, and it has a specific 2D or 3D expression of it, then that is something that you would want to design register it. So the prerequisites of the design, as it goes with all the other IPs, it has to be novel and original. So it has to be your own creation, right? It should not be applicable to a functional article, and should be visible on a finished article. Um, it should significantly distinguishable from the other known designs that are out in the market. um, right? So a good examples of that is a lot of product companies who would create specific type of designs for let's say their wallets or or purses, which give an identity to themselves, which are unique and novel, and they would want to protect those design elements that nobody else can reproduce. That becomes a good use case of design application. And then obviously there shouldn't be a prior publication or disclosure of the design, which is also a very iconic case in that we are going to look at. In terms of Crocs, came up with a brilliant design, but that was prior to the registration was made public, and so now you would also find other companies like Liberty and all making the same kind of shoes, which are typically should have been very unique to Crocs themselves, right? So some of the examples of the design, obviously the labels would create unique designs, and they don't want their designs to be copied by others. All of these um, all of these could be good use cases of designs where there is an aesthetic aspect or element attached to it. um, there is a 2D or 3D representation to it. So some pens which are very uniquely designed, or the outfits, the garments, the products which speak of a particular type of design which they own as an identity. This could be a design registration. um, any mode of construction, building, not not typically a design element. Anything broadly that is covered under the Trademarks Act or Copyrights Act, uh, is not designed. For a good example, the chocolate bar shape is actually an identity to the brand in itself, and that is why Toblerone has gone for a trademark registration. And so usually it is not a design element, but it is more of a brand attachment to it, and that is why it falls under the Trademarks Act protection. So that's a distinction, thin line distinction, in that case. um, so typical objectives of uh, Design Act: protection of original design. So the creators are creating unique designs, and they should be protected, which becomes a reward to the creator. It becomes a unique selling point for them, and so they can actually expand with that in the market, and safeguard their interest where the competitors cannot actually come in and replicate their designs. And eventually it also becomes an IP for the business. And so as the asset class, right, is you have an exclusivity to produce and reproduce those designs, but nobody else can actually go ahead and copy that. We largely went through this. So obviously it has to be a novel and original to be able to design registered. It must be a unique, and prior publication is not there. um, for the design. An explicit application is required, which also we will discuss in copyright, wherein the explicit registration is not required. Probably one of the only IP categories where a registration is not mandatory, but definitely beneficial in a lot of cases. But design has to have an explicit application to be made, and obviously it doesn't have to be in contrary of the order or the morality, right? The designs are typically um, registered and protected for 15 years. Initially, it is a 10 years of granting, and then there can be a further application of extension, which has another 5 years. So in that case, it is a 10 plus 5, total 15 years of protection that you get over the design uniqueness, right? And obviously, there's a filing process to that. Let's not really go into a lot of process details and stuff like that. We'll rather discuss the case studies. So I was just talking about um, Crocs as a company, and there is a case in the Delhi High Court, uh, Crocs versus Liberty. Most of the people identify Crocs as a shoe wear, selling a specific type of designed shoes, right, which obviously has a unique identity in itself. But at the same time, the judgment was given in against, and the primary reason for that being that the design was already out in the market before an explicit application was made to protect it. And that is why it becomes a commonly available information, in that is how Liberty was able to actually reproduce the same style and design and sell it under their brand of Liberty shoes. Right. So that's one case. The other case scenario wherein um, it can't be um, it cannot be a component which is an absolute essential to the design. And so when Reliance Industries actually um, tried to file a design, around the nozzle angle, um, as a solely detected function, and uh, so that was rejected for a design registration, and the other people could actually sort of reproduce the same kind of design now, which is very, very common across the toilet sanitization industry, wherein everybody really kind of goes in with with an angled nozzle, and so on and so forth. um, right, some of the things which cannot be registered as designs is, let's say, your signs, your flags, emblems. um, if it is a structure or a building, typically not a design, uh, design registrable item. um, any trade variants or any size differences. So if you have a particular type of design, you're just kind of making it small or big, usually not a great not a great item for qualification for design registrations. um, right, your um, um, generally it kind of talks about the external look and feel and external appearance of the of the product, and so it can't really be dealing with the internal mechanism or the if or the functionalities. And if so, and if that is more inventive in nature and creating difference in performance and whatnot, typically would qualify as an invention, innovation, and be patentable rather than a design registered. So these are some of the things which um, which cannot be covered under the design registration. In fact, I believe, missed out on copyrights. Nonetheless, let me meanwhile we can answer the questions, but I do intend to take up copyrights as well. Let me just figure that out.
Hello.
Hello.
Just a second, sir.
Sure.
So the first question is, can a specific idea be protected, patented? Can a prototype that is also in ideation be patented?
Yes. So ideally, what should happen in that case is, if you are not completely done with building out a product or specific technology which is inventive or innovative in nature, you would ideally consider to file a provisional patent. In the provisional patent, you identify the invention that you are working upon, the approach, and all of those things, and then you get about 12 months to actually complete the development of the technology or the development of the invention. And at that point of time, you should file a full specification. So that would ideally be a way to go around it.
Okay. I hope, Ashish, you got your answer.
And
Yes, thanks.
Next question is, can a business model be patented?
a business model typically is not something which you would be able to patent. It has to be strictly an invention or innovation which has an industrial application to it, wherein a business model remains very generic. If the business model involves a particular invention which has a commercialization over it, that is something that you would be able to patent. So just a business plan or a business model is not something which ideally sort of falls uh, under patenting.
Okay. Next question is, can we apply for IPR for my web product?
So IPR in general is a very vast term, right? So if you are creating a web product, which is, let's say, a SaaS company, right, and you are going to create a branding. For example, Microsoft is a brand which produces a lot of different softwares. So Microsoft as a brand is an IP which is which is trademarked, right? Because it is a brand identity. At the same time, if you are creating a software, software in itself is not something which is patented in India. There are overseas patentability of it. But at the same time, if that works with a specific set of hardware in a more meaningful way, you can actually categorize that as a system and you can try and patent that. Right. And then obviously, with your business, a lot of people would consider, copywriting their uh, unique and novel expressions in terms of the content that they produce, or the videos that they produce, and so on and so forth. So in general, there are a lot of different applicabilities to a software business, wherein you can try and gain multiple IPs. But primarily, I think if you're creating a brand, obviously trademark is something which you are going to definitely go after if it qualifies as a wholesome system, a combination of software and hardware. That is something which has a patentability as well.
Okay, next question is Swastika from Swastika Maitra. I have published a manuscript on plant-based products for viral inhibition. I have published this data now. Can I move with publishing paper for patenting?
So typically, if it is available um, in the general uh, domain, or a public domain, that loses its patentability. Again, this has to be checked case by case, but ideally what I would suggest is, if it's commonly available, the know-how is commonly available in a public domain, it usually loses the patentability.
What should we do for educational models or software? I'll repeat again. What should we do for educational models or software patent?
So a software patent is, as I told, just by itself, the software is not something um, which is currently patentable. It's a software code in itself is not patentable in India. If it's a system along with a hardware, that has a patentability. Nonetheless, if you're trying to protect the software in itself, some other countries like US does have a patentability for software.
Okay. So if someone comes with any new mathematical techniques, then it is fall in which category?
So if it is a new mathematical technique which is an invention or an innovation, and it has a commercial or industrial application to it, which can technically be defined as an invention, then ideally that could fall under um, fall under a patentability. But again, that is something which sort of needs to be uh, checked on a case by case basis. Very difficult to make a judgment.
Can any correction be made in registered trademark?
There can be. So if you have applied for a mark and you want to make changes in terms of ownership, or make changes in terms of minor corrections and stuff like that, you can actually file a TMM through which you can make a change over it. If it is already a registered mark and then you want to transfer the ownership, then there is a separate process for trademark assignment and transfership of the rights. So yeah. And then obviously, if it is a registered mark and you want to change the mark, then obviously it is a separate application.
Should I move forward with the next one?
Sure, I can cover the copyright however you prefer.
Whatever you feel. Okay.
Sure, I think we'll go on. Yeah, I think if
Okay.
you are.
So how idea to be registered when at present I don't know the structure of the organization such as partnership firm or company.
Right. So let's say if you are trying to register a patent over an invention and you don't really have a business as of yet, um, at that point of time, you can also file for a patent individually, right, on an individual or an inventor's name. At the same time, once your business and partnership is in place, ideally it would be the business who would want to own the intellectual property, because that is how the valuations of those intellectual properties are going to be brought into the valuation of the business, right? And so at that point of time, you can also assign or transfer the rights. So that could be one option. And that is a very popular option, because a lot of times you don't really want to miss out on or you want to sense the urgency in filing, because you don't want to miss out on not getting it just because you delayed that uh, for the business to be formally in place. So that definitely can be a case. It can be filed in an individual name, which can later be either sold off in terms of usage rights, or the selling of the patent in itself, and transfer the wholesome rights to the business at that point of time.
I'll move to the next one. Can a bacteria-based bioformulation for organic agricultural production be patented?
You would have to see the product. It's a very broad claim, but if it's creating, if it's a formulation based, you see a lot of pharma companies filing patents for their formulations, which yield better results. So if it is of something of that sort, wherein it kind of creates better efficiencies in the process, in the results that you see as a end resource or end product, and the performance of that, ideally I would think that that should be patented.
Next is, what is the difference between national and international patents?
So there is nothing as such international patents, right? The patent rights are typically geography bounded. Then obviously there is WIPO that is in place, which has a treaty of commonly trading countries, and where through the route of PCT, you can extend your application to get protection under other countries as well. Uh, it's a formal process to do so, and at the same time, the granting purview is also reserved for each country, and so it is not that you apply for one patent and you really get rights of exclusivity across the globe. So that doesn't happen that way.
Okay, the next is, can patent be withdrawn?
Can patent be withdrawn? It can be made generic for general usage. That would be okay. So if you wouldn't want to reserve the patent rights and you want to make it publicly available, there is a lot of open source systems, Tesla being a great example of it, wherein they made their technology available for usage for all the car companies. There is a very iconic case across the globe is Tesla quickly realized that if they only produce EVs under their invented technology, they will not be able to grow the market share so rapidly. But if there are more participants in the world who would use their technology invention and build uh, a very big EV market in itself, then obviously them becoming a market leader of that, they will already benefit out of it. And so they actually made it an open source technology available for everyone. The other good example of that is Google, who made Android to be an open source item. Java is an open source item. So there are some cases wherein the inventors don't really reserve the rights, and it is available in the public market.
Can we make search for design and copyright before making application, as we can do for trademark?
Yeah, so patent search is a very prominent product. So what is technically called a prior art search, which is rather a little more technical in nature, and it goes through what are the pre-existing patents available, which are similar, and in fact, for the matter of fact, it is very highly recommended, because that is going to actually help you either make a decision not to spend a lot of money and resources after patenting, or if at all a distinguishing point that is going to make a better case for you for your patentability. So to kind of alter your patent drafting in a way that clearly distinguishes the claims, or even the explanation of the invention and or innovation, and from what is already a pre-existing, which kind of sets the ground for rejection. So patent search absolutely is something which I would highly recommend before actually going through full specification filing, which rather is very expensive affair.
Next question is, can we use tagline as brand?
Tagline becomes a brand identity, right? So for a lot of brands, whether that's McDonald's, I'm loving it, Nike's just do it, uh, they actually start becoming the positioning of the brand, and it is definitely a very integral part of their branding strategy in itself, right? um, like connecting people, or I'm loving it, just do it, uh, kar lo duniya mutti mein, gateway to goodness. um, Local brands also doing it very phenomenally. Like there's a local brand called Hearty Mart, which does which is a kirana or a provision store in a tier 2 cities, and they say घर के पास सब घर के पास सबसे खास, something like that, which creates a branding identity, which demonstrates the sentiments of the brand, and very integral part of the branding strategy.
So the next is, for trademark, do we need to trademark logo, company name, and tagline separately?
Ideally, yes. If you are a shoestring budget, then to start with, you can do it as one composite, but that does not then give you a lot of flexibility in changing that. So time and again, the brands change their taglines, or how their device, or their logo, or their abstract in the logo is registered, so obviously the brand name remains more or less constant. They can change the device design, they can change the taglines. If you have registered all of that at once, then it becomes difficult to protect, when when it is going to be tested over time, and keep changing that and stuff like that. So if you have that ability and flexibility, ideally I would suggest to separately market.
I'll take few more questions, sir.
Sure.
Can I first publish the paper and file patent later?
Ideally not. It becomes publicly available information, and so loses the essence of patentability.
Is patent registered in a single country applicable worldwide? Because we
It
see
is.
USA companies complaining against Indian manufacturers for producing a USA patented item.
Typically, it is geographic territorial bound. If they have gone through a PCT way and protected that in India, that might be a case where it is protected in multiple countries. But ideally, the benefits and the protection remains geographically bounded.
Can we patent healthy food product formulation?
I didn't get that.
Maybe some food formulation, food product, mixtures.
Mixtures typically are not patented as such. Again, it depends on what kind of application they're looking at, but a lot of times that they remain, trade secrets. Uh, for example, recipes like Coca-Cola or Pepsi, um, you know, they would ideally remain to be secret recipes and not something. One thing that also people uh, can consider is whenever there is an application or registration that happens explicitly, that becomes a publicly available document, and so it also exposes the know-hows, the secrets, of those things, and primarily in recipes. So a lot of you know food based items, may that be the composition in gutka industry, they have like very specific ingredients that are mixed in a very secretive way to produce that flavor, or may that be Coca-Cola or Pepsi, or all of those recipes are typically highly secretive, and they don't really uh, they're not really registered as such.
What is the lifespan of pharmaceutical patents in India?
Any patent is typically about 20 years.
Does Indian patent give protection worldwide?
Again, the same answer is no. Um, so the patents need to be filed in other countries through a PCT route, um, to be able to get protection in the other countries.
Next is just sharing as common example to learn more. So typically, when you buy a home, you get an index copy which proves that the particular home space belongs solely to you. So to protect the property of inventor, innovator, designers in future, do you believe we need some sort of process that's nationalized, standardized like this? Since the present and future is going to be dominated by the knowledge economy and idea economy, and everyone should get credit for their ideas.
So that is why usually you would go with the registration process, right? The registration is a proof of ownership at that point of time.
Can a new application or use of existing product be patented?
Can a new application of existing, so if it is already existing, if it's only a new application of what is currently existingly available in the market, the patentability is typically bleak.
One company have patent in India, then same product can get by any other company in any other country.
Depends, but possible.
Value of patent changes with the country of filing. Say US patent is more valuable than Indian for the same.
It ideally would depend on the market that you are serving and your target market size on that, right? So if you created some sort of invention which is only applicable in India, which is very nuanced situation in India, I would ideally value that more in India as opposed to US, because your commercialization and your industrial applicability is much bigger in the Indian market in that case. Um, so it really depends on what your invention is, what is an applicable market to that, and where you can make the best commercialization possibilities, and that is where I would ideally value it more, rather than uh, you know um, sort of a cookie cutter thought process that it values more in the US versus India. Shouldn't be that way, I guess.
Can you lease your idea in the form of patent?
Can you lease your idea in form of patent? So you can actually commercialize your patent, and create a revenue stream out of either giving rights to production and earn royalty out of it, or outright sell it, transfer it. So yes, that becomes a property that you can in a way either lease out or sell off.
That's it, sir.
Fair. Great. All right, so we get back to the subject. That was quite a rapid fire. All right. So again, the fourth one. Excuse me for not including that in the presentation, but I'll just you use another one that I have on this one. So anyways, the copyrights are typically unique expressions which are either literary work, artistic work, musical work, right, cinematographies, sound records, novels, books, literature, blogs, songs, right? All of these things, which is an original literary work or artistic work, can be copyrighted, right? Um, so who usually should look at um, copywriting their work? Typically authors, producers, publishers, owners or creators of the artistic work, composers, performers, artists, even in some cases businesses where they are publishing unique content on their websites, or um, in very rare case scenarios we also see if logo is an artistic work, right, wherein it is like it's an abstract logo or device which is very artistically done, it also can be and should be protected under the Copyrights Act. So these are some of the people and cases where you can register a copyright, right, and so does imitation of an idea of registered copyright amount to an infringement? No, it does not. Copyright is not an idea but an expression of an idea, ideally. um, and I'll probably just go away from the structured slides. But let's talk about copyrights in general. um, so copyright usually gives you an exclusive um, sort of right to use that content, use that artistic work, um, which becomes your own ownership. And somebody infringing upon it, you can either challenge that, sue that, claim damages, stop the usage, as you can do in the other intellectual properties. Typically your copyrights are available for the lifetime of the author and the 60 years plus, and you can have an exclusive right of usage. There are very good cases where let's say the Sippies created Sholay as a film, and they're still kind of making money out of the royalties, that being a very highly popular movie and stuff like that. Unlike most of the other intellectual properties that we sort of studied and talked about today, um, copyright is something which doesn't explicitly have to be registered. And so what happens in that case is, the moment you create an original artistic or literary work, is when you actually get the rights vested under the Copyrights Act, and it becomes your own your own intellectual property. um, right, typically the registration helps you to establish the primary evidence, if at all that is being challenged in the in the matter of court or otherwise. Um, so usually not for everything small and tiny that you produce as a new artwork or as a new uh, sort of blog on your website, you shouldn't really keep copywriting all of those things. I mean, it's a choice, but you necessarily don't need to, right? So what is the workaround of that? How do you establish the fact that you had been the original creator of that work? Is a lot of times you also suggest people, if they are creating some sort of content which they want to protect and they don't really have means or budget for kind of registering copyrights for each of those, they should ideally start sending those over an email to themselves, which kind of keeps a third party, let's say Google servers or the email engines, timestamp on it, which also helps them establish the case, if at all being challenged, that this was the time that originally I had created, and this is a validation over it, right? Sometimes also people get those things notarized and keep a copy of that, to have a third party validation on it. So again, having said that, copyright is something which you get as a vested right, right away at the time of creation of the content. um, Having an explicit registration definitely gives you an edge. So anything that is very meaningful, let's say you're writing written a song, written a novel, um, that usually um, would want to would want to copyright that. Some of the good sort of cases to discuss under the copyrights is very a few years back. Actually, there was a publisher in Kolkata, a very small time, which who created a novel and became a great hit on the streets of Kolkata, amongst the booksellers and the readers, was based on Harry Potter, right? And if I'm not mistaken, it was named as Harry Potter Kolkata or something like that, um, wherein a kid, you know in the novel, in the story, the kid goes to watch a movie uh, of Harry Potter and doesn't get a ticket. He comes back home, and then he has a dream about the movie, and then the characters are being used to kind of narrate a story in the dream, and that is how the entire book was written and published, and it became a hit in the market. And obviously, because those expressions, characters in the story was a copyright item for Harry Potter, the author could actually stop uh, the books to be further um, further sold, and obviously stop the usage of those characters and stuff like that. But that becomes like a interesting case for how the copyright infringements could happen. um, Sometimes also people have a question on um, a fan art, whether that is an infringement of copyright. So ideally, if it is not to produce a revenue stream, it is just an expression uh, of a fan art, um, and it can be categorized as a fair use, and so probably be pardoned from the copyright infringement, right? So those are some of the use cases that people always kind of, if you can kind of take somebody else's content and really modify that a little bit, use it. There are certain leeways that have been granted. Also, if it is used for public awareness, if it is used for uh, you know those kind of activities, usually something, and it strictly does not have a monetary benefit coming out of it, something that can be pardoned from a copyright infringement, an infringement case. um, so that's another angle to kind of look at some of the things, if it is being used for scholarships, research, research reporting, news items, news channels, you would find them kind of use certain originally created content for reporting purposes and stuff like that. So there, all of those things kind of fall under the fair use and would be excused from the infringement, um, right? um, and I think we discussed the case of uh, Harry Potter Kolkata, a very very interesting case where eventually Warner Brothers could come in, legally challenge that, after they already actually sold about 15,000 copies of that, and restrict a usage. So that becomes a very interesting case in itself. Right. So I think, yeah, that's about copyright. So we'll very quickly, kind of look at, different intellectual properties that we have, and take a very quick recap, and then we can open it up for questions as well. But usually anything that's a creation of mind, which has an industrial application, which has a commercial application, which is something which has been created by an intellect and not necessarily a physical property, is an intellectual property, right? Broad categories being trademarks, copyrights, patents, and industrial designs. The key takeaways, or the thumb rule is anything that really relates to the branding element of the business, may that be logo, slogan, scent, in some cases, uh, you know the music, or jingle, uh, it all of these things which help your customers distinguish your product, your company, your business from the competitors. It is usually a trademarkable item. Anything that is a unique creation in the sense of novel creation, in the sense of literary or artwork, or a unique expression of the writer, composer, art producers, um, content writers. All of these things are typically copyrightable items. um, Anything that relates to an invention or an innovation, which is not available in the commonly known resources, or general publications, and something which is novel in nature, something which is inventive and innovative in nature, which has a commercial application and enhances the performance or efficiencies in certain ways. That is usually something that would be patented. And eventually anything that deals with the externals, aesthetics of the product, which becomes a unique identity, usually becomes a design, or industrial design, related matters. So these are the very broad categories of IPs. And all of these in totality obviously help you build a brand positioning, help you distinguish yourself from the competition, uh, gives you exclusive rights of certain usage, and that is how you kind of restrict others to make the markets more competitive or crowded. It also helps you either license it or sell it against a value and create a revenue stream out of it. And eventually it becomes an asset, or an asset class that is adding up to the value of your business. And most of the new age businesses that you see, they're very, very heavily valued in terms of intellectual properties as opposed to the physical property holdings that they have. So in a nutshell, it becomes very important not to just create intellectual property, but also to nurture it and to protect it by law. And that is where the intellectual property rights come in play. With that, I think I open this up for any questions that you might have, and very happy to answer.
There are few more questions. The
Mhm.
first is, if anyone adds some special character, example, Legalwiz is the original and someone does Legalwiz, will it be trademarked?
It wouldn't be ideally, or it can at least be challenged on the grounds that it has the same pronunciation, it might have the same look and feel, it might have the same color combinations that have been used. So ideally, you would think it this way. If at all, you think that it is going to create a confusion in your user class or your customer class or your general brand perception of your company, right? It is something that you would want to restrict, right? So if somebody register as another company wherein Legalwiz WIZ, instead of that they say WHIZ, ideally I would want to put an objection opposition over it.
For app name, is there any need of any copyright or registration?
The app name, if you are popularizing that as a product, which becomes an identity of your business, it ideally would be a trademarkable item.
Is there any limit to copyright?
Limit as in, if it's about the years, then copyrights is a lifetime plus 60 years of protection. Yeah.
Any building also has to pass from design or patent?
The building doesn't ideally become patentability is strictly towards the innovation invention, right? Usually the building materials are not inclusive of design registrations.
How would the dynamics of IP law be in the case of NFT infringement?
So NFTs are a very sort of new area, right? We've studied some of the NFTs and how they are they are protected, and if the NFT has a visual representation, you can actually copyright it, but at the same time it has a commercial angle to it, and so at the time of copywriting it, you might also have to produce a trademark certification over it. So ideally, at this point of time, we studied a few and done a few, right, for protecting NFTs. Like, Gary, we had an NFT launched in the name of VFriends, and there are trademarks and copyrights both that have been claimed over those NFTs and stuff like that. So yeah, it's a fairly new space. And the world is evolving very fast on the blockchain, NFT, Web 3.0 and whatnot. But yeah, people are trying to catch up with that.
What are your thoughts on intellectual property rights in metaverse?
What are my thoughts? It is too early to say, to be very honest. I don't know if I know enough to really comment on that. But definitely a lot of things would be uh, will become a digital representation, and unique representations, whether that is spaces being created in metaverse, whether that is that there are virtual experiences being created in metaverse, and so a lot of these things will eventually come to some sort of IP protection, whether that is branding element through a trademark, whether that is an expressive element through a copyright. But I mean, too early to say, but I would ideally believe that that a lot of these things will relate to branding elements or the unique work that's been that is being produced.
So next is few classical movies of Bollywood and Hollywood. Two in the past have been made repeatedly after some 50 plus years have been passed after the original copyright were ended. But my question is whether the movie right holder can continue renewing the right of the movie for an infinite time.
There is no infinity in copyright, so it's the creator's age plus 60 years. There can also be specific rights given to reproduce the same things. Again, if it's only about so depending on what kind of rights uh, that have been secured and given as a reproduction rights, it depends how quickly or how uh, I think there are some Hollywood songs which have been brought into Bollywood, and with taking explicit rights over it and so on and so forth. So it becomes another avenue of commercialization at that point of time for the holder of the original asset class, and that can be done that way. But there is no perpetuity in ownership at that point of time.
Who may help in commercialization of grassroots innovators IPR in India?
In terms of registration, obviously a lot of law firms, companies like us, like Legalwiz and whatnot, um, right, to rightfully protect it. The commercialization, definitely a lot of incubation centers, acceleration centers, GUSEC being one of the primary ones in Gujarat, to kind of incubate such companies and help them with the commercialization roadmap. In the grassroots innovation, obviously, uh, you also have like specialized people who are working on that. So some of the XIIM professors who have um, established their grassroots innovation and only centric to the rural economy and innovation and invention. um, you know they are very handy with taking grassroots innovation to commercialization roadmap. So yeah, there are but ideally I would approach an incubation center who understands the dynamics of startups and supports them with the right set of ecosystem. Highly recommend GeoSec for that, obviously. So yeah.
So next is, how can we make search? Where can we make search for availability of copyright and design?
So there is a search process for designs, and there's a formal process that is in place. Ideally that would be that, or should be done by the professionals. So I would very highly recommend that being done by the professionals. And there are public resources that are available to search. For example, if you want to search a trademark, go to the trademark ministry's website, and has a search functionality. You can kind of try out the combinations with the respective classes and stuff like that, and you can get the search results or reports.
Next is, we have an app with hardware and multiple music created by us. We are very early startup. We offered by government incubation for patent and copyright. Can we go for it?
If you are just an app, we would have to assess the patentability, obviously. If it's only a software code, um, and I think I missed the question, but if they are into the music industry and they have their own music production, obviously that becomes very worthy of being copyrighted.
Next is, can you please brief about evaluation of IP and valuation methods?
Valuation of IP is a very, very vast field. Again, depends on what is the value of your IP on the current commercialization basis. What is the wholesome market that is available for that? What could be the penetration of it? How quickly can you commercialize? How much value can you gain out of it? Right. So all of these things kind of make up to the valuation of IP. It is largely also an art than a very specific science, um, right? But it's a uh, it really kind of differs case by case on how do you come to the best IP valuation. uh, you know if you are talking about the brand, then what is the brand recall, what is the positioning, how many customers that are there in the market who associate strongly with the brand, and so on and so forth, which can kind of get your brand valuation or your trademark valuation, which becomes a goodwill component to your balance sheet. Right. The patented items obviously has a commercialization to a different angle, wherein what is the usability, what is the applicability, what is the potential commercialization, and so on and so forth. So yeah.
Mr. Hiren, sorry to skip your question. I am on to your question. How to search trademark related information in free database, and which are paid database available for search for trademarks?
Trademark has I actually IP India website has a free trademark search tool. So that's the best way, and most of the lawyers also end up using that. Is you can go into an IP India website and perform a trademark search. You can try out the combination of your brands and enter the class that you are trying to register the mark in, and you can actually get the search report for free over there.
Next is, what are your thoughts on automotive design patents? For example, Mahindra Auto's Bolero model is the exact replica of much highly valued G63 AMG model by Mercedes-Benz. Same goes for their Thar model, which is the copy of the Jeep Wrangler.
If it is design protective, then obviously there would be an infringement case. If it is not, then it is replicable, right? How we saw in the case of Crocs, where Liberty could actually replicate the design and put a commercial selling on it. So
Okay. Last two questions, sir. Can country patent on their defense weapons?
can company patent if it is a technology that is inventive, innovative in nature, if it has a commercialization, if it is produced by uh, if let's say a privately held company produces certain type of technology, uh, it should have an applicability of patent.
Can you tell about IP rights in pharmaceutical industry like COVID vaccine manufacturing and other ones?
The IP rights are widely available and widely availed. Pharmaceutical industry being one of the biggest industries to actually file patents on the formulations, um, on the APIs, on the components that and the mix of components that they use to, kind of create and the medicines and cure certain type of medicines. That is how you find a lot of medicines. Even the production cost is dirt cheap. You find them expensive in the market because there's a lot of research and development that goes in, a lot of years of expertise, experience, and research funds that go in to actually create a cure for a disease. And so the pharmaceutical companies end up protecting that formulation, and until it becomes available as a generic medicine where everybody can start producing the same formulation. Once the patent rights are done with, it stays as a monopoly in the market.
Okay. So next is, if you make a blog first and then convert it into a book, is it a good idea?
You may want to, because anyways it is a copyrightable thing, and if the blog is under your ownership, you don't explicitly have to copyright it. The novelty in writing, it remains your right at the time of, or it is retained as a right at the time of creation itself, right? So if you repurpose that into a book, ideally it would carry forward as your own right. It's just a means of publication at that point of time. So you can do a book, an ebook, an audio book on the same story. So the author of Harry Potter would have given rights to Warner Brothers to use her stories and create a movie out of it, right?
Can a patent be filed directly to Indian Patent Office without involving lawyers?
So you have to, ideally you would get through a patent attorney, um, and you get a patent well drafted. You make your claims very specific, um, and that usually should be the best way to go around it.
One last request from participants, if you can share the presentation with them.
Sure, absolutely. I'll do that. I'll first ask my designer to add copyrights to it. I will definitely share it. Share it with you guys, and can further, or if you can provide me the participant list.
Sure, I'll do.
Anyhow, I'll definitely be more than thrilled to share the presentation if anybody wants to kind of have further questions. Definitely, I'd be more than happy to help out.
I would request every participant to, if you need access to the presentation, kindly email us on programs@gusec.edu.in. Before concluding, can I just request everyone to turn on your cameras? I just want to click a picture and so for our social media. Sir, if you can just stop sharing the screen.
Sure, absolutely.
Thank you. Thank you so much. Thank you. Thank you so much. Thank you, sir, for joining the call.
Thanks everyone for having me
For
today.
an amazing session. Thank you, everyone, for joining.
Thank you. Take care. Thanks.
Bye-bye.
Bye.